The EFF contends that the absence of guidelines on what qualifies as a quote-unquote serious offence and the rules that govern the disciplining of members of parliament opens it up to abuse due to the structure which is based on majoritarianism. This as the party in its central complaint submitted that the rules provide the committee with wide powers and discretion without putting in place safeguards to guide against arbitrariness, partiality, bias and abuse. Council was probed extensively on what these guidelines and sanctions would look like.
Well, what we know...
I'll tell you why. I don't want to give an order which actually is nonsense. In other words,
Fair.
Guidelines. What kind of guidelines
Fair.
are you saying? What I'm
Fair.
trying to say is, I'm not asking you to tell me ABC.
Yes.
But what would that maybe look like, which would essentially close the notion of serious in such specificity to meet your point?
No, firstly, it would, as a matter of principle, it would not have to be with such specificity to make my point, because, no, hold on, with all due respect, because with respect, what we know from the authorities around the fettering of discretion is it depends on the nature of the power that's being exercised and the kind of consideration that the decision maker has to make. It could be examples of seriousness. It doesn't have to be X, Y, or Z offences, and that's the point. In the absence of guidelines to otherwise qualify what might be serious is open to abuse. And that's what the court recognised in Darwood. It's also what it recognised in affordable medicines.
Parliament, however, is of the view that the EFF's case is inconsistent with the facts and is internally contradictory. Counsel on behalf of the respondent stated that the EFF's case sought to claim that the National Assembly targeted members of the EFF, a claim the respondent says is untrue, submitting that Parliament disciplined members of the EFF because they have been guilty of parliamentary offences. Counsel on behalf of Parliament further emphasised that Parliament is not a court of law and its task is very different.
You cannot expect Parliament to act like a court. If you expect Parliament to act like a court, one of two things is going to happen. We're either going to have processes that are so long, like the public protective process, that it's unable to do its work, or it is constantly going to be acting unlawfully because it cannot meet the standard that's been set for it. So that's what happens if you say to Parliament, you must act like a court, you must analyse evidence like a court, you must apply the rules of evidence, you must apply the rules of discovery, you must record all your things in the way that a court would record its judgment, otherwise you haven't done your job. It's unworkable and it's not what the Constitution requires.
As a result, Parliament asked the court to dismiss the application, which it termed as abusive, with costs. Kenny Mapanga, SABC News, Johannesburg.